Kevin with Crayon Law Firm, and I'm here to tell you the 7 stages of an EEO complaint within the federal sector. This is for federal sector employees who are thinking about filing an EEO complaint or who have already filed an EEO complaint and are confused about what stage of the proceedings they are in or what comes next. Look online, you really don't see anything that describes the litigation process from beginning to end. The first major stage of an EEO complaint is making informal contact. This is an early chance for resolution. I have resolved many cases in what's called mediation. Mediation is where a neutral third party helps the parties come to a settlement. This is a chance to nip it in the bud. The second stage of EEO litigation is what's called the formal complaint. It's very important that you properly research the case law and properly frame your issues in the formal complaint stage. The formal complaint stage kickstarts your lawsuit. Once you file a formal complaint within the 15-day deadline, you will receive an acknowledgement letter. Then you will receive another follow-up letter. This letter is the acceptance or rejection of your claims. Very important that you follow up within a very short time period, often only a week, to file any objections that you have as to any claims that were accepted or denied, or if you feel that any of the claims were improperly framed. Stage 3 of the litigation is what we call the investigative stage. This is where an investigator is assigned to your case. Now, this investigator is an independent contractor who is supposed to be neutral and is independent of the agency. You do not have to pay for this investigator. This investigator will usually go out and get affidavits or sworn testimony from you and from management. This is a chance to submit potential witnesses to the investigator and submit potential exhibits. We as attorneys keep the investigator on track to make sure he's investigating the things that we need to prove your case. This file that the investigator will compile will be the very foundation for what comes next. At the end of the investigation, you will be given a choice to either elect to do a final agency decision or to participate in a hearing. Almost 90% of the time, you will want to elect the hearing option. For more information on that, contact Crayon Law Firm if you are at that fork in the road. Stage 4 of the EEO litigation is probably the most important part of the case for you to get representation on if you have not done so thus far. We will have clients who have tried to go it alone, but then they get to this stage. Why is it important that you retain an attorney at this stage? Well, because at this stage, the agency that discriminated against you or took the adverse actions against you, it's out of their hands. It's in their attorney's hands at this point. And their attorneys are looking for ways to dismiss your case, to disprove your case. The number one thing that I see is that people who try to represent themselves through this stage often miss many of the deadlines. You receive an acknowledgement order from the judge. The judge gives you certain deadlines. You only have 20 days to actually initiate discovery. Discovery is where you request the information and evidence. You really have to prove your case. Oftentimes, the agency may be evasive. They may not comply with deadlines. They're 9-to-5ers. They clock out at the end of the day. They're overwhelmed. So, oftentimes, they don't do the things that they're supposed to do. And you need to turn this around to your advantage. And most importantly, you need to preserve your rights to get the evidence that you need to prove your case. Furthermore, the agency can also initiate discovery against you. This means that they can also request documents and information from you. And it's very important how you respond to these requests. The agency will have filed what's called a motion for summary judgment, asking the court to dismiss your case without a trial, without a hearing. This will be based on the evidence or lack of evidence that was gathered during the discovery phase. At the end of the discovery phase, you will have stage 5. You are one step away from actually having your day in court. This is where the judge issues a hearing order. The judge will expect you to submit a list of witnesses, a list of exhibits. This is the stage where you will have an evidentiary hearing or a pre-hearing conference with the judge, where you will discuss what evidence will be excluded or included. This is also the stage where settlement tends to occur, because this is the stage where all of the evidence should be in at some point during this stage. Each side should know the strengths and weaknesses of their case at this stage. The sixth stage of the litigation is the hearing stage, the trial phase. This is your chance to have your day in court. We get to present witnesses, exhibits, and evidence in your favor to prove your case. These hearings can be one day, sometimes they can be several days. After the hearing, the judge will issue his or her decision. If it's in your favor, the judge usually will do a hearing, a separate hearing, just on damages, pain and suffering, monetary damages. This is the money part. The seventh stage of an EEO case is the appeals stage. This is where you file an appeal with the Office of Federal Operations. This is the EEOC's headquarters. This happens after a hearing, or if the case is disposed of earlier. If you win your case, the agency may want to file an appeal. Or if you do not get the decision you desired, you may decide to file an appeal. So that's the 7 major stages of EEO litigation. Whatever stage you're in, contact Crayon Law Firm. We know what we're doing, and we'd be happy to discuss your options and strategies with you.